Now come to Article 3.
Yes.
So as far as Article 3 is concerned, let's assume, I've made my arguments on the proviso already, that under 356 it can't be done. But now let's assume the proviso is not there. Let's assume that all this is valid. Let's assume. How can they make the union, a state into a union territory? Under what provision of law? Under what power? Then my Lord put to them that there may be a situation of a national security situation. So therefore, temporarily, you may need to do that. But the national security situation is dealt with by Article 352 of the Constitution. 352 to 359 deals with all this. So how can you use Article 3 to do that? You can't use a power in 3, and of course, that's not their case also. It's nobody's case that this was being done because of national security. Pulwama happened, in February 2019 during President's rule. And then they had elections in May 2019. And what is the justification of keeping, not constituting the state, for 4.5 years? Under what constitutional basis can you say that I will keep a particular state as union territory for 4.5 years? You say you are going to have municipal elections. You're going to have local government elections. There are a number of, the tourism has increased. So what's the impediment then? What's the constitutional logic, or basis on the basis of which you can deny the people of Kashmir a statehood? And India is a union of states. As your Lordship rightly said, my Lord the Chief Justice, that a union territory can get the status of a state, but not the other way around. It's never happened in the history of this country. Actually, 272, 273, all this has never happened in the history of this country. Not even during emergency. So, this one last thing, and then I'm done. Now, this is dated 17th May 1949. But as your Lordship will notice here, and this is all documents are provided in the annexures, that at this point in time, Iyengar, Sheikh Abdullah, and Vallabhbhai Patel and Nehru were all getting together to draft 370. And on 17th May 1949 is a letter written by Gopalaswamy Iyengar, and he tells Vallabhbhai, here's the draft. Jawaharlal ji has seen and approved of it. Will you kindly let Jawaharlal ji know, direct as to your approval of it? No, directly tell him as to your approval of it. He will issue the letter to Sheikh Abdullah only after receiving your approval. Vallabhbhai Patel was the architect of 370. Nothing was done without his approval. In fact, he went to Parliament. Kindly see, there's another letter, another document here. So it's very interesting, Willis. 3rd November. But look at Sardar Patel's letter at page 46, yes, of 306A. Kindly come to 244, Malas. After a great deal of discussion, I could persuade the party to accept all the changes except the last one. He was the one who was interacting with the party. And he was the one who finally, persuaded the party to accept all the changes except one. And of course, Sheikh Abdullah thereafter.
Sure, there was a political compromise to ensure enough flexibility at later.
Absolutely. All I'm saying is everybody was part of that process.
You are accepting the second part also, that there was flexibility to ensure that in future it works itself out.
That's correct. But all that I'm saying is, they were all collaborating. The key players were collaborating in drafting 370, and this is how they understood 372.
That argument you have already
I've already made. I'm not repeating it, Malad. I just wanted to read these letters. So, and then I've got this table, Malad, of Jammu Kashmir, Malad, where Jammu Kashmir is the head of most of the states in India in every parameter. But we are not concerned with that, Malad. I just put it. The normal process is, Malad, for the governor has the power to keep the assembly under suspended animation without the aid and advice of the Council of Ministers. That power is given under 92 of the Jammu Kashmir Constitution, which he did. Which he did, Malas, on 20th of June 2018. Now, Malas, the Jammu Kashmir Constitution also says that this will last only for 6 months. That such a decision of the governor will last only for 6 months. That is set out in Section 92, subclause 3. That such an order will last only for 6 months. Now, which means by 19th of December, there should have been revival of the assembly, because the assembly was not dissolved. See the political motives and the illegality in the whole process. This can't go beyond 6 months, beyond 19th December. So he has to revive the assembly. There's no dissolution. So on 19th December, he dissolves the assembly. On 21st November, he dissolves the assembly. Now, dissolution can't take place without the aid and advice of Council of Ministers. Section 53 of the Jammu and Kashmir Constitution. Section 36, 38 and 92 are the only exceptions under the Jammu and Kashmir Constitution. I mentioned it earlier also, where the governor can act on his own. But 53 is not. 35, 38 and 92. So, Malads, he could not have dissolved. And after dissolution, 356 can't be imposed.
After
Malads dissolution, Article 356 cannot be imposed. These are Constitution Bench judgments of this court. Now, your Lordship asked me the question last time also, you've been asking other council also, why did you not challenge it? Number one, we could not challenge as far as the governor's order of 20th June is concerned, because under the Constitution of Jammu Kashmir, he had to put the government back in place within 6 months. Where was the occasion to challenge it? Council of Ministers would have been back in place.
What would happen if there's no conceivable government formation possible?
Whereas he can't do it. That's a point.
Mr. Sibal, that's little saying that because it was tenure or 6 months, I can't challenge this wrong.
No, I said I haven't challenged it.
You can't challenge it.
I can't. When I said I can't, I mean we knew, Malas, that
you can certainly challenge it, and people do challenge it.
They do, but Malas, the government was to come back in place. Malas was to be put back in place.
That may be little.
The government was to be put back in place within 6 months.
So my only question is how, if in 6 months no government is feasible, possible, then necessity would require a resolution, would it not? What would happen? Let us say there is no government possible. Then whom will he put back in? What kind of governors?
So, Malas, what you do is you impose 356, then you dissolve. With the process of under 356, Malas, I've explained it last time also, that you keep the assembly under suspended animation. You see if you can form a government or not, because 356 is a temporary provision to restore democracy. If you find that there is no possibility, after imposing 356, you dissolve and hold elections. That's the process.
So then the dissolution should have taken place under the rubric of Article 356.
That's correct. That's correct. And that's a Constitution Bench judgment. I'll show that to your Lordship straight away. Because the governor was ruling for 6 months. Where is the question of 356? So you do it this way, tell the governor, whereas he sort of puts it in suspended animation, less the 6 months almost part, when the government, when the two parties say that, look, we are ready to form the government, but that's not proved, Malas. Then on 19th December, President rule is imposed after the assembly is dissolved on 21st of November. Couldn't be done. Then if that's bad, and that has to be decided by this court, because that's the basis of 202, 272 and 273. So whether we challenge it or not, that's the very basis.
This can happen, right? Because the Section 92 power is sui generis.
Yes.
Normally, even when
he has to act on the aid and advice. No.
Normally, when an assembly is placed under suspended animation, as we call it, that's also an exercise of the 356 power.
That's on the recommendation of the governor, Malas.
That's on the recommendation of the governor.
Of the governor, that it can't be carried on in accordance with the provisions of the Constitution. Then 356 is, well, that's what happened.
And the recommendation of the governor again is on aid and advice, or that would not be on aid and advice?
No, it never is.
It will never be on aid.
Never is.
So the question doesn't arise. So we're just wondering, according to you, the dissolution of the assembly on 19th of December is wrong, 19th of November is wrong, because it had to be by
November. Yeah,
25th of November is wrong.
21st November, yeah.
Because there had to be aid and advice. There was no aid and advice.
Apart from that, Malas, where was the occasion for 356 at all? Because he was running the administration. Malas, he's running the administration. There cannot be a constitutional failure. That happens only when the government cannot run in accordance with the provisions of the Constitution.
But therefore, no, but we're just testing it like this. Suppose the governor's dissolution is, according to you, incorrect. The consequence would be that at the end of 6 months, The Legislative Assembly has to be restored
No, no.
The suspension would come to an end after
after
6 months.
6 months.
Yes. Then
If
the Council of
suspend-
Ministers have to be
Council of Ministers has to be formed.
correct.
Now, taking your argument to the logical conclusion that, look, the dissolution was wrong and the governor had to necessarily at the end of 6 months
Before.
restore, before 6 months, restore the Legislative Assembly,
Yeah.
lift the suspended animation,
Yes.
invite a government. In which case, can the government of India not have then exercised, the president not have exercised the power under 350?
Correct. So then he would have had to make a recommendation that this is not, they are not functioning in accordance with the provisions of the Constitution because the governor was ruling for 6 months. Where is the occasion, Malas, for him to at that time exercise that power?
But if no state government is possible, nobody is agreeing to combine together.
But that's fine, Malas,
Keep the facts aside.
in which you impose 356. Don't dissolve it. Malas, that's the whole problem. You impose 356.
And keep the assembly in suspended animation.
That's always the case. I'll give you several notifications. I don't have the time. That's always the case. What you do is you keep the assembly under suspended animation. You try and, you have to restore democracy. So at some stage you feel that now it's time to hold elections. You dissolve the assembly and announce elections. That's the process followed in every 356 proclamation. You never dissolve the assembly immediately, but then you have to hold elections. Well, the democratic process can't be stultified, can't be used in this fashion. Because this was, as I said, this is a political decision. It has nothing to do with the Constitution. I've been saying that from day one, Malas. These are political decisions. Even 272, 273 is political. Maybe I'll...
How much more time now?
Well, not too much, Malas. I want others also to argue, Malas. But I've been trying to sort of not even refer to anything and just argue orally, Malas. So that's all I have to say, Malas. I just want to say at the end that, Malas, as I said, Malas, your lordships, Malas, ultimately is the arbiter of what this constitution should look like and how it's to be interpreted. But I only want to request your lordships to think of one thing, that as I walk out in silence of this court, let the court speak on behalf of the people of India. Because this court, this government, or any government, any administration acts for the people of India. And it should not be that acts are done when a part of the people of India are silent, who have never been consulted, and whose fate will be decided by the cabinet sitting here without reference to parliament, without reference to legislature, without reference to the people. Because people are central to the Constitution of India. We should not forget that. Thank you very much for giving me this.